In a very general sense, the first thing that we do as lawyers at Shapiro and Ford is we will take a look and see what marital property exists, which of course begs the question, what is marital property? Well, marital property you should look at as property that was acquired during two time periods. The first time period is the date of the marriage of the parties, and the next time period is the date that either party actually files for judgment for a divorce in Supreme Court. That is the start point and the end point. All property that is acquired in the marriage during those periods of time is presumed to be marital property. That could include a house, it could include real estate, it could include a pension for one or both spouses, bank accounts, it could include cars and personal items of property. Marital property is property that is acquired between those 2 points in time. It's presumptively marital property. Does that mean it's always marital? No, it does not. For example, there are certain times when you can acquire property and it is separate property, which means not part of the marital estate. For example, if you receive an inheritance during that period of time because one of your parents dies, so long as that inheritance goes to you and is not mixed with any other marital property and remains separate, that would be separate property. Other forms of separate property are property that is acquired before the commencement of the marriage itself or after the commencement of the filing of the marriage. So first what we would do at Shapiro and Ford is determine what property is marital and then determine how that property is going to be distributed.
Keith Shapiro and Ford, making our voice heard so your voice is heard.